Your brand is one of your most valuable assets. So why risk losing it? When it comes to protecting your business, two terms often come up: trademarks and copyrights. But do you really understand the difference between the two? And more importantly, how they affect your brand? Copyrights are designed to safeguard creative works, but trademarks, well, they're all about protecting the name, logo, or mark that represents your business. But what does that really mean for you? Why should you care about whether you have a trademark? The answer might surprise you. Stick with me as we break down the essential differences and explore why trademark protection is far more critical than many realize, and how getting it wrong could leave your business exposed. Let's talk about the difference between copyright and trademark. Copyright is designed to protect the works of artists. It's the work that's being protected, and it can't be used or copied in any way without the artist's permission. Trademark is the law's protection of a mark associated with the source of a product or a service. Trademark law also then protects the public's right to associate a product or service with the mark. So for example, if you go to buy some shoes and they say Nike on them, you can expect a certain degree of quality from that shoe after you buy it. Nobody else is allowed under law to say Nike on the shoe except Nike. So by remembering that trademarks protect the public's right to associate a mark with the source of goods or services, and trademark protects the company's right to their reputation and making that connection between their goods and services. By understanding that, we understand the purpose of trademark is very different from the purpose of copyright, which is to protect artists and their actual work from being used or copied in a way they didn't consent to. Although copyright and trademark are both intellectual properties, their purposes are very different. They operate in very different ways, and they are totally separate as far as the body of laws that govern those areas. They just happen to be two types of intellectual property, but they're very different. So we know what trademarks are. Now, what are your ways to protect them? If somebody else is using a similar mark that is causing confusion to your consumers, you probably have a trademark infringement case. Now, if you have registered your trademark, you have much stronger rights than if you have just relied on the common law trademark, because common law trademark doesn't acquire all of the benefits that trademark registration gives you. You can do a copyright registration without needing an attorney, but trademark registration generally requires an attorney. And the reason is there are a few pieces. First, the attorney is going to carefully define what it is you're protecting so that you don't accidentally get the wrong description, something that's too broad or too narrow or too limited or otherwise problematic under the law. Second, the attorney is going to identify the right categories and select the right classification so that your trademark gets the broadest protection possible. I've seen many times where individuals use online services, Rocket Matter, LegalZoom, etc. And unfortunately, those are just computer software services. You're specifically agreeing when you use those that you're not having an attorney represent you. There's been a lot of litigation about that. And the bottom line is those services are only allowed to exist as long as it is a software service using some sort of wizard where you're making the decisions. And unfortunately, a lot of times, and when it's too late, consumers and business owners have found out they did it wrong. You don't normally find out right away that it's a problem. You might, but often you find out later when somebody else starts using your mark, and all of a sudden you don't have the protections you thought you did. So I highly recommend you utilize a trademark attorney when you want to get a registered trademark for your name or your brand or your logo. One requirement under trademark law is you can't allow a person to infringe your trademark and just not do anything about it. In other words, the law requires that you monitor use of your mark and enforce your trademark rights. If you don't, the law basically says, we're not going to give you those rights if you don't at least enforce them. And you can't wait so long that some competitor who's using an infringing name starts building that brand. You need to take action relatively quickly to get them to stop. How do you do that? Step number one, make sure you are monitoring anybody else that's using your name out there. You can do that with Google Alerts. You can pay for a trademark service if you want, a trademark monitoring service, or you can manually go online and do Google searches to see, is anybody else using a confusingly similar name or mark as you in your industry. Then what do? You send them a cease and desist letter typically. Now, why not just send them a lawsuit? The reason is often you can just get them to stop if you send them a cease and desist letter. Usually that's sent by an attorney. It could be sent by you, but often the recipient of a letter that's not from an attorney may not take it as seriously. In other words, when a cease and desist letter comes from an attorney, usually the recipient takes it more seriously because they realize, first, the attorney is probably right about the law. Second, the person who hired the attorney is serious enough to spend some money to send a legitimate cease and desist letter to them. Now, if you'd like to know more about how to avoid trouble like this, I have a free resource at aaronhall.com/free. I provide information for business owners of small to mid-sized companies on how to avoid common legal problems. That includes a PDF. It includes videos talking about important issues. I'm Aaron Hall. I'm an attorney for business owners and entrepreneurial companies. If you'd like, subscribe to this channel so you can get more educational content like this.